Hello, guys. Please take a look at this. The XRP lawyer, John Datton, suspects a possible SEC rug pull ahead of the sport BTC ETF approval and also in the other headline SEC request judge to determine whether certain crypto assets or securities. We are going to look at them one after the other. So please sit tight and don't forget to click on the like and subscribe button so you won't miss out on our next update. Thank you, and let's continue with our video. There are still intriguing developments and cases about the Bitcoin markets. In a lawsuit against Terraform Labs and its co-founder Do Kwon, the Securities and Exchange Commission SEC has made a significant request in this regard. Rather than letting a jury decide whether or not particular cryptocurrency assets qualify as securities, they have asked the court to make that determination. The SEC motion for the court procedure that SEC contended in a December 4th filing in the Southern District of New York that the jury should decide the legal question of whether or not cryptocurrency is classified as securities under the Commission's guidelines rather than a factual one. SEC authorities claim that the lawsuit against Terraform Labs has sparked a debate about whether the Howey test should be used to classify some cryptocurrencies as securities or not. SEC representatives defended the situation by saying the following: "It is undeniably true that the defendant's sales of crypto assets entail financial investments in joint ventures with the express aim of reaping rewards from the labors of others. There isn't a factual dispute here, but the jury may be asked questions to settle disagreements on crucial details. There are no factual disputes regarding the terms of the offerings and sales, the manner in which the defendants' cryptocurrency assets were sold, and the statements they made in their marketing materials and related promotions. Conflict between the crypto market and the SEC. The SEC has decided to categorize several cryptocurrencies as securities and has started pursuing enforcement actions against Coinbase and Binance. A federal judge decided in July in a dispute against Ripple that XRP did not have to be categorized as a security, enabling the SEC to withdraw its accusations against Brad Garlinghouse, the CEO of Ripple Labs, and Chris Larson, the chairman. There is now a dispute between legislators and regulators regarding the role that the SEC should play in the legal regulation of cryptocurrency assets. The debate centers on the question of which currencies will be categorized as securities or commodities in the US. According to several analysts, the SEC may soon determine whether to authorize a product that is being traded for the first time on a spot cryptocurrency exchange. John Datton, the creator of Crypto Loss and an XRP lawyer, is making news once more. Datton thought it interesting to repost a post by former SEC officer John Reed Stark on X. A significant bull market is being sparked by the increasing interest in the impending approval date of a spot Bitcoin ETF. After 19 months, Bitcoin burst beyond the $44,000 barrier, according to experts who believe that a spot Bitcoin ETF may debut between December 7 and 10. John Reed Stark has added an unwelcome spice amidst these rumors. John Datton's response to Stark's statement, expert in law Joe saw that the SEC assertion that language in the recent BlackRock shares S1 filing raises questions about Bitcoin as a potential securities. Joe draws attention to the sexy, surprising action and asks why, given the likelihood that the application will be denied, they would require such language. Trading Bitcoin on exchanges will be difficult if the SEC declares the digital asset to be a security. Additionally, this will draw regulatory attention and perhaps cause Bitcoin to lose its current traction. John Reed Stark considers two scenarios, but he concedes that a 90% chance of SEC approval for a Bitcoin spot ETF seems arbitrary. He pointed out that the VSECI initiatives exposed grave worries over the ETF's effect on investors. He also criticizes SEC Chair Gensler's non-traditional style, which is defined by a disregard for divergent viewpoints within the agency. Furthermore, Stark draws attention to Gensler's prior involvement in legal matters, such as his lawsuit against Covington Burling and his backing of contentious regulations. Responding to Stark's extensive examination of SEC Chief Gensler's intuition, John Datton anticipates a potential obstacle. According to reports, there may be a covert backlash despite the 90% chance of spot Bitcoin acceptance driving up the price of the cryptocurrency. Referring to the likely consequence of the spot Bitcoin ETF rejection as a regulatory rug pull, Datton clarified SEC Gensler's stringent stance on the cryptocurrency. According to Bitcoin core developer Luke, Bitcoin ordinals and BRDR 20 will disappear will approval be granted to spot Bitcoin ETF. The comments were made at a time when the price of Bitcoin exceeded $44,000 and the market was extremely optimistic. The decision to authorize spot Bitcoin ETFs is still pending, though. Joe Original Post, Bloomberg analyst James Sifart offered an additional hypothesis. According to Sifart's earlier claims, there is a probability that a spot Bitcoin approval may occur around December 10. Additionally, he forecasts that ARK Invest's spot Bitcoin ETF will be approved on January 10 of the next year. In the midst of all these market turbulence, Bitcoin might quickly surpass $50,000 if a spot ETF is approved. However, the price of Bitcoin would find it challenging to regain the same momentum if the SEC rejects all files designating the cryptocurrency as a security. The judge presiding over Terraform Labs' legal action has been asked by the U.S. Securities and Exchange Commission to determine if Terraform issued and sold securities that were not registered. The SEC contends that the status of securities should not be decided by a jury. The status of securities is not a question for the jury to find out. In the SEC lawsuit against Do Kwon, the former CEO of Terraform Labs, the agency requested that a jury not be allowed to decide on the accused securities. The SEC contended that deciding whether particular cryptocurrency assets qualify as securities is a legal question to be determined by the court, not a factual question for the jury in a submission to the U.S. District Court for the Southern District of New York. According to the SEC, posing the question of whether any cryptocurrency in the Terraform case met the Howey test requirements for security sparked conversation about the subject. According to the SEC's filings, the fact that the defendant's crypto asset offerings comprised financial investments made in a joint venture with the hope of reaping financial rewards for their labors is undeniably true. The securities agency also asserts there are no factual disagreements regarding the fundamental aspects in this case, even if the jury may be asked questions by the court to settle them. Regarding the terms of the offers and sales, the manner in which the defendant's cryptocurrency assets were sold, or the statements made by the defendants in their marketing materials and promotional campaigns, there are no factual disputes. The SEC further claims that Terra neglected to address in its opposition petition for summary judgment the SEC's accusation that it offered and sold cryptocurrency as unregistered securities. According to the legal team representing the SEC, the undisputed fact that brought up in earlier papers are sufficient to satisfy the governing legal standard and should thus be decided by Judge Jed Rakoff. Summary judgment should be allowed by Judge Rakoff. SEC maintains that the case is straightforward and that Judge Rakoff should issue a summary judgment because this is routinely done in such circumstances. Judge Annalisa Torres issued a summary ruling in the SEC Ripple case, albeit not totally in the SEC favor. According to Judge Torres, the programmatic sales of XRP by Ripple did not meet the criteria for securities under the Howey test. Citing Judge Torres' decision, Terraform attempted to have the case against it dismissed. Judge Rakoff, however, disagreed with the decision, stating that the Terraform and Ripple instances are distinct from one another. Disclaimer: the only goal of this article is informational. It is not meant to serve as financial, investing, tax, legal, or other advice.